The Juneau World Affairs Council and Veterans for Peace Chapter 100, in collaboration with KTOO, present the 2025 Juneau World Affairs Forum Unratified, the International Law of the Sea Treaties and Their Potential for Protecting Arctic Resources and Cultures. In this lecture, the UN Convention on Law of the Sea, an Introduction. Professor Nafziger outlines the history of UN-CLOS, significant issues, how UN-CLOS is organized, and the status of ratification of the UN-CLOS. Nafziger is Professor of International Law at Willamette University.
Well, thank you very much, whoever you are. I want to first thank the Juneau World Affairs Council and the Veterans for Peace, as well as the other sponsors that have put together this program. I always like to get back to Juneau, which all began when I was a law student clear across the country. And I had the opportunity one summer to clerk for a Juneau law firm. I'd always wanted to visit here, and I've enjoyed coming back ever since, very much thanks to Bruce Botello, to whom I will refer in another moment or two. But you scarcely need me, given what you know I'm expected to present. This room is full of experts on UNCLOS and the law of the sea, and you probably don't need someone who comes without any PowerPoint, given the quality of the PowerPoint we've just seen from Steve White. But I'm glad to be here, and I think for some of you may not have the background on UNCLOS. I want all of us to be on the same page and talking about it. So let me then just refer again to my good friend Bruce Botello, who of course is always a spark plug in these Juneau events and was a prime mover in setting up this program. You may not know it from the deceptive color of his hair, but he was once a student. When I was going through the interview process at Willamette University, where fortunately I got a job and have been ever since, one of the faculty members came up to me rather desperately during the interview and said, we desperately need a judge for a moot court competition. Would you be willing to do it? At the risk of hearing a groan from Bruce as I tell this story for the 10th time in his presence, well, what choice did I have? I was interviewing for a job. I couldn't say no. So they marched me into a moot court room to hear a moot court competition. And I was simply blown away by the preparation and presentation of this guy, Bruce Botello, a student in the competition. And I thought, Willamette's for me if all the students are like this. Unfortunately, they didn't turn out to be all Bruce Botellos, and of course he's gone on to much greater glory. That gives me an excuse, I guess, just to pay tribute really to my employer. Not too many years after Bruce, Lisa Murkowski came along, and we were very pleased to have her as a Willamette graduate. I noticed that in the latest issue of the American Bar Association journal, there's an entire feature article on Nicole Nelson, who had been the executive director, I think, is correct, of the Alaska Legal Services Corporation, is now doing a lot in community justice work. And so we're very proud of our Alaska oriented graduates of my law school. Jay Inslee, the last governor of Washington, is also a graduate of our law school, but he didn't have the wisdom to reside a little further north in Alaska and become the Alaska governor, so he had to settle for being governor of Washington. Okay, enough said to grease the wheels of my presentation. Let me begin in talking about UNCLOS with a little history that goes all the way back to the ancient Greek maritime codes. The Code of Rhodes, which you may be familiar, was a maritime code fundamentally. It had a big effect, still has some effect, in maritime law. And as the years wore on, it became a kind of customary international law for governing maritime areas. Then in the 17th century, time of Hugo Grotius, the so-called father, though he really wasn't, of international law, a well-known Dutch jurist by the name of Binkershoek got the idea that the territory of a coastal state should be extended by 3 nautical miles, out to sea. Why 3 nautical miles? Because there's the reach of a cannon, so-called cannon rule. And if a coastal state purported to have the same kind of sovereignty over territorial waters it had over its own land, it ought to be able to defend those waters. And they could do that out to 3 miles. So the 3-mile limit, with which I think most of you are familiar, remained a kind of customary international law for several centuries. Things really began to change, however, in this last century, and it seemed time to develop a treaty, or maybe more than one treaty, on the law of the sea to govern everything that was becoming an issue involving fishing rights, involving jurisdiction of coastal states, involving innocent passage of warships, and a whole lot that in one way or another we'll be hearing about during this conference. So it was time to develop a law of the sea that was coherent and written and could be as much as possible depended upon. And that led to a United Nations conference on the law of the sea, which took place in 1958. And it led to 4 treaties, the decision having been reached that it would be too difficult to cover everything. It needed to be covered in one single treaty at that time. So there was a treaty on territorial waters and a contiguous zone. I'll come back to that. Secondly, there was a treaty on the continental shelf, and I'll come back to that. Third, on the high seas, and fourth, on fishing and conservation of living resources. Those 4 treaties, to which the United States became a party, and we still are a party to those 4 treaties, really constituted the foundation for the modern law of treaties. Within just a year or two, The United Nations had concluded, however, that already there were questions that needed to be addressed that hadn't been addressed by those treaties. And so they convened a second conference in 1960, just 2 years later. And it focused almost entirely on the single question of the breadth of the territorial sea, or territorial waters, which, as I say, under customary international law had abided by the canon rule out to 3 miles. And that centered on a proposal for doubling territorial waters to 6 miles. By one vote, the proposal to do that failed, and that was the end of the second Law of the Sea conference. So we can kind of forget about that, but a whole lot else was developing. For example, a leading Maltese jurist and diplomat, Arvid Pardo, established a principle that still has considerable significance that we sort of all take for granted these days, namely the principle of a common heritage of mankind, or humankind, we might say today. And that still has been an important principle, particularly when we turn to the seabed, which we will in a few minutes. A lot of new problems had emerged in terms of jurisdiction, in terms of innocent passage of ships, in terms of environmental issues that were beginning to emerge in that period of time. And so once again, the United Nations was called upon to convene a conference to develop the Law of the Sea. And that led to the third and last of the Law of the Sea conventions, otherwise known to us as UNCLOS, as a conference, and UNCLOS also as a convention that emerged. That conference took place effectively between 1974, although it was initiated the year before, and 8 years later, they wanted to do it right. When finally the draft convention was completed in 1982. That is what we call UNCLOS today. All right, so the United States took a very active role in the process of negotiations. We always do when it comes to multilateral treaties, but all too often, I'm tempted to say almost always, but at least all too often, the United States, with its resources and keen interest in a particular subject of international law, will be a leader in negotiations only to terminate its commitment to the project that's emerged. And UNCLOS to this day is no exception. Let me go into a little more detail about that. The UNCLOS that emerged in 1982, which consists of, it's a very lengthy, very complex multilateral treaty. And as I say that, I'm reminded to qualify what I said just a minute ago. The United States tends to play a very active role in multilateral conferences leading to multilateral treaties, only to terminate its commitment. But that's partly because, given U.S. power status particularly, the United States certainly prefers bilateral treaties, or it can simply negotiate with one other party rather than the entire world. So bilateral treaties were continuing to emerge, having to do with very specific aspects of the law of the sea. But in any event, in 1982, Um, the 17 parts of this complicated UNCLOS with its additional annexes explaining a lot, all of that was, for the most part, acceptable to the United States. After all, we'd worked long and hard on it, and even though we have had this reputation of pulling out from a particular multilateral project when the job is completed, nevertheless, we were prepared to commit ourselves to it, except for notorious Part 11. This is the part on the seabed, and I think most of you know about the provisions about the seabed, and I'll summarize them in a few minutes, that not only led the United States to refuse to even sign the treaty, let alone process it through the Senate for advice and consent and eventual ratification by the United States. The United States did that, at the same time making it clear that many of the provisions were entirely acceptable and would be accepted by the United States as customary international law. For example, UNCLOS then extended territorial waters out to 12 miles. So that has been the rule ever since the United States fairly quick, under President Reagan, quite quickly accepted that as a matter of customary international law. And there's a good deal in UNCLOS that even in the Reagan administration was accepted, but there was great opposition to the seabed provisions of Part 11 of 17 parts, as I said. Okay, so let's then look at UNCLOS in a little more detail. Let's note that in terms of the structure, you should keep in mind that much of it is defined by zones of coastal state authority outward from the coastal state's land. And that's not all there is to it, but when we ask a question like, well, what does it say concerning fishing rights? That's a very difficult question. It varies depending on the particular zone of authority. It depends upon commitments of international cooperation, a whole lot else. But let's begin with baselines. These are the lines right along a coast at low tide, from which all of the zones out to sea that provide for coastal state authority of various sorts emanate. You begin with baselines, and they can be normal baselines, is the term, that just purport to follow the coastline at low tide, or they can be straight baselines. Some 90 countries have adopted the idea of straight baselines, which are generally along the same coastal profile, but simply connect major points along the coast, rather than following every little inlet and every eccentricity of the course. They simply connect the points. And those are called straight baselines. And jumping ahead, one of the controversies with which the United States is faced, and it'll be interesting to hear speakers on this, has to do with a decision made by Canada years ago to connect the points of its many northern islands with straight baselines in order to define Canadian jurisdiction. And aside from the questions that arise with Canada having to do with traffic through the northern waters of Canada, that's another issue as to whether those straight baselines are acceptable. Okay, so we begin with the baselines and then we proceed out from there. And then it's really easy. The first, as you might expect, the first zone of coastal state authority are the territorial waters of the territorial zone, extending out to 12 nautical miles. The authority of the coastal state is tantamount to its authority over land. There is, however, considerable provision for the rights of non-coastal states, of other states than a particular one in point, with considerable rights accruing to them in using those same territorial waters. We then move out a little further to what's called the contiguous zone. And the contiguous zone emanates not just 12 miles from the baselines, but 24 miles, and enables the coastal state to assume necessary control over the waters to protect customs, laws and regulations, fiscal, that is tax laws and regulations, immigration laws and so-called sanitary laws, meaning health laws, four very important aspects of coastal state jurisdiction, of course, and contiguous zone enables them to do that. At that point, we can call in the Coast Guard and rely upon coastal state authority to protect those laws and regulations. Then moving out from there, we come to something with a very close Alaska connection, and that's the exclusive economic zone, the EEZ, that I think Steve projected some information about that. Exclusive economic zone exists beyond the 24 nautical miles of the contiguous zone. Just jumping ahead slightly, the United States has, thanks to Alaska, and I guess Hawaii to some extent, in any event, the United States has the largest exclusive economic zone in the world. What's the Alaska connection? Well, that began in 1956 with the Magnuson-Stevens Fisheries Conservation and Management Act. The name Stevens probably rings a bell with Alaskans. That was Ted Stevens. And with Warren Magnuson, the senator from Washington, they sponsored this piece of legislation to protect, to conserve and manage fisheries. A new idea, basically, on a comprehensive basis. And within not too many more years, the Magnuson-Stevens Act evolved into the idea of the exclusive economic zone, which enables a coastal state to assume full sovereignty over the conservation and management and exploration and exploitation of resources, whether living or non-living. whether we're talking about fish or we're talking about minerals. And if we're talking about fish, it includes in another belt of authority, the continental shelf. It includes sedentary fish, but the sedentary fish are not covered by the provisions for the exclusive economic zone, but it gives a lot of authority to coastal states over an extensive zone all the way out to 200 nautical miles, but only 200 nautical miles, to perform those functions related to living and non-living resources. There are lots of side issues having to do with cooperation and having to do with the rights of foreign states within the exclusive economic zone. We really don't have time to get into some of that, although maybe you have questions, I'd be glad to try to respond to them. But that's what we mean by the EEZ, the exclusive economic zone. Beyond that, and as I say, each one of these zones of authority has a separate set of provisions, more or less in order of the distance from the baselines in their appearance within the UNCLOS document. Finally, after the exclusive economic zone, we come to the high seas, which was subject to great debate back in the 17th century as the nation-state system was developing. Hugo Grotius wrote a famous book related to the law of the seas, and our friend Binkershuk established the 3-mile rule. In any event, the high seas have generally stood for freedom of the seas. And there's a provision in UNCLOS that establishes the various freedoms inter alia, so that there are others that aren't enumerated, as I think will be argued by one of the speakers this afternoon in opposition to UNCLOS. That there's really nothing in UNCLOS that prevents coastal state exploitation of mineral resources. Well, that topic then leads me to define the continental shelf and the extension of the continental shelf to the seabed and subsoil. In other words, so far I've just been talking about the so-called superjacent waters of the continental shelf, above the continental shelf. Now I'm going to talk about the continental shelf and its extension. The continental shelf is defined as a natural prolongation of a land mass. There's more to the definition, but basically that's the idea, the extension of the land mass underwater. And every coastal state gets to claim a 200-mile limit to the continental shelf. One of the three institutions, I'll define them in a few minutes, but one of the three institutions set up by UNCLOS is a commission on the determination of the extent of the continental shelf beyond 200 miles, and that institution is established at the United Nations headquarters. In any event, I've just said it, sometimes the continental shelf may extend beyond 200 miles. It can only do that if, in fact, certain geomorphic criteria are satisfied, certain geologic formations exist beyond 200 miles that would enable a coastal state to claim more than 200 miles and then to go to this commission in the UN to get approval of that. And that would enable such a coastal state to extend its continental shelf out to 350 miles, 350 nautical miles. It's a long ways off. And so we have then a couple of regimes. Incidentally, a number of coastal states, for example, on the west coast of South America, have prolongations of the landmass that drop off suddenly. And when they do that, technically speaking, that's not anything beyond that, which is often far short of 200 miles. Anything short of that cannot be considered a prolongation of the landmass. But nevertheless, as I said before, every coastal state, even such coastal states that are deprived of an extensive prolongation of the landmass, can enjoy the claim of a 200-mile limit. Okay, so then we come to the seabed, and therein lies huge questions ever since the United States refused to sign, let alone eventually gain the advice and consent of the Senate to eventual ratification of UNCLOS. We stopped short because the seabed provisions of Part 11 seemed anathema to the thinking of the Reagan administration at the time. Why? Well, what the original set of provisions did was very ambitious in providing for certain limitations on, well, let me first say, why are we so interested in the seabed? It's because of the vast deposits of minerals. You may have heard of the nodules that often consist of, manganese, nickel, cobalt, and copper. And enormous quantities, particularly in distinct deposits on the seabed or seafloor. And what the original UNCLOS did, it's since been amended, as I'll explain, was to vest enormous authority in more or less international public entities that included an assembly of all parties to UNCLOS, a council of, some 30 or so elected representatives to carry out basic policy pronouncements and decision-making, and something called the enterprise. Sounds like private enterprise, doesn't it? But it wasn't regarded that way. Very public entity with a very important function of actually carrying out the excavation, exploration and exploitation of the minerals themselves, to put, in other words, a kind of a United Nations originating body in a very critical position of carrying out the mining of these vast quantities of minerals that are potentially very significant, especially in modern technology, where there's a great need for more than the land mined minerals that are also found in those nodules on the seabed and seafloor. So what has been the experience? Well, in 1982, when UNCLOS was open for signature by parties, there was great excitement about a new industry that would be controlled in the way I've described, very publicly, very internationally, to the benefit of all in responding to, even then, the needs, technological needs of humankind. For a variety of reasons having to do with a crash in minerals production, having to do with discovery of land-based minerals of the sort represented in those nodules on the seabed, and most of all, the difficulty in establishing infrastructure for mining and for processing the nodules. Nothing has happened in 43 years. What has happened is a couple of things. One, that licenses through the International Seabed Authority, as it's called, that includes the Assembly, the Council, and the Enterprise, and a couple of technical and fiscally related bodies. The authority has issued licenses for exploration. One example is Lockheed Martin, which received such a license, I think about 12 years ago, to explore for manganese nodules in particular. And a Canadian corporation called the Metals Corporation, with a subsidiary in the United States, has also received several licenses for exploration, but not for exploitation, because that still is not financially or commercially feasible. The United States even doesn't have the processing infrastructure if the nodules were mined to make them commercially feasible. So we still don't have that. And what that has meant is a huge debate related to the fact that although in terms of exploration there have long since been regulations for the issuance of licensing, issuance and use of licensing, the same is not true when it comes to exploiting or mining our resources. We still don't have a model code. We still don't have regulations for that. Lots of issues there, and we can talk about that if I haven't bored you silly with just this introduction to the whole seabed issue. But it continues to exist despite the excitement, the best hopes back in 1982 of a new industry that would accrue to the benefit of the United States. Okay, well, I want to leave a little time for questions, but I think it's important to identify just a couple of very recent developments. Just this, in the last several months, really just since June. First of all, there was a regular assembly of the parties to UNCLOS, which of course does not include the United States. I meant to say that the United States was not the only party to refuse to sign the treaty. The United States was joined by Israel, Turkey, and Venezuela, kind of an odd combination of countries, all four of which still have not ratified the treaty, and Turkey and Israel at least have not signed it yet. The United States did eventually sign what was called the Articles of Implementation in 1994. So the United States is a signatory to these Articles of implementation ever since 1994, as well as regarding, ever since the Reagan administration, really, regarding much of the rest of the treaty is customary international law binding on the United States. So what were the Articles the Articles of Implementation? The United States wanted to get other countries to reject UNCLOS in its original form. And the United States largely succeeded. They agreed just on the eve of the coming into effect of UNCLOS in 1994, just on the eve of that, during the Clinton administration, thanks in no small measure to the Secretary of State, Madeleine Albright, the United States did get other countries to agree to make some changes, such as making ineffective limitations on production, ineffective requirements of transfer of technology, assuring the United States that it would have a place on the council that it might not otherwise have if it weren't elected, and in a number of ways appeasing the United States, all in the expectation, which never materialized, that the United States would immediately become a party to UNCLOS. We still aren't a party. Let me just say that that's despite the fact that all presidents, with the exception of Reagan, in terms of Part 11, and President Trump have supported our accession to the treaty. And I think two of the biggest advocates were Clinton. I've already referred to his role, and his successor, George W. Bush. George W. Bush had two exemplary legal advisors, William Howard Taft IV, no less, followed by John Bellinger, an extraordinary international lawyer, both of which really pushed for UNCLOS. So we've had a lot of support at the highest level. And may I say that in efforts where Senator Murkowski has been steadfast in her support of UNCLOS, in her efforts, she was joined a dozen or so years ago by no less than top brass in the military, other political leaders, the U.S. Chamber of Commerce, the American Petroleum Institute, the National Association of Manufacturers, none of the last name being very closely identified with multilateral developments. And Senator Murkowski really has stood out in her support for UNCLOS, along with many others. So, to conclude, I do want to pick up where I left off a couple of minutes ago with recent developments. And one of these has been a really very admirable resolution drafted in part by Senator Murkowski and joined on a bipartisan basis, one independent Senator King from Maine, and at least one, maybe two Republicans, as well as Democrats, in a resolution to again put UNCLOS before Congress for, we all know, some of the issues about the role of Congress these days, but in any event, it's a wonderful resolution. And that came down just a couple of months ago. In addition, the International Court of Justice in The Hague issued an advisory opinion on state obligations regarding climate change. And though that advisory opinion doesn't specifically refer to UNCLOS, or let alone to the issues under UNCLOS, there's a lot in it that is applicable, having to do with a duty to prevent pollution, a duty to cooperate in the avoidance of pollution, precautionary principle, don't take any action unless you're really sure that it's not going to have an environmental effect, and so on and so forth. So there's a lot in it that can be applied in the instance of the law of the sea. Well, that's pretty much what I had to say, and hope that wasn't too much.
That was Professor Jim Nafziger presenting the UN Convention on Law of the Sea, an Introduction. It was recorded October 10th, 2025 at KTOO on the unceded territories of the Occoquan on Tlingit-Ani as part of the 2025 Juneau World Affairs Forum, Unratified, the International Law of the Sea Treaties and their potential for protecting Arctic resources and cultures. Produced by the Juneau World Affairs Council and Veterans for Peace Chapter 100 in collaboration with KTOO, with support from Core Alaska Kensington Mine, Wastman & Associates, Ramada Inn,